Good morning. The House Criminal Justice Committee will come to order. Now we're going to move on to our next topic, and I just wanted to say a couple of things since this is a pretty big issue. I want to make sure that everyone talks with respect and consideration for one another. We're going to keep it civil. This is a emotionally fraught issue, and it's also a fairly legally complicated issue. So we will take our time going through this testimony today, and if we need to come back and revisit this at our next committee meeting, we will do that. Representative O'Neill and Representative Vanderwall. And Representative Wilson, you're welcome to join if you wish. Are you going to stay on the dais? Or? I guess I'll go. Okay, thank you. This is a lot of testosterone. Sure. Whenever you're ready, representatives.
Thank you, Madam Chair, members of this Criminal Justice Committee. Thank you for this opportunity. I'm here today to testify on the Juvenile Life Without Parole package and talk about the opportunities we can create for our youth. Michigan has more juveniles sentenced to life without parole than any other state. This is unacceptable. 26 states already have laws on the books banning life without parole, while 7 others have no juveniles serving such harsh sentences. House Bills 4660 through 4164 and Senate Bill Comparison Bills 119 through 123 would eliminate life without parole for youth under the age of 19. This legislation aligns with Michigan juvenile sentencing laws with those of the majority of states in our country. It aligns Michigan juvenile sentencing laws with what is fair and merciful. These bills provide a minimum sentence of 10 years and a max that is no more than 60 years for certain crimes. The packages will allow for a parole review after 10 years of time served. This 10 years review process will take into consideration many factors of the crime and deciding the juvenile's access to parole. Some of these factors include age, maturity, family home environment, circumstances of the offense, such as their role in the offense, and if a peer pressure was a factor in the crime. I also like to point out, Madam Chair and colleagues, that it costs the United States around $2.5 million a year to imprison a juvenile serving life without parole. However, but that price tag for the state shouldn't really matter when it comes to the price that these children are paying. Their lives, lost opportunities for a second chance. The law clearly distinguishes children from adults. The research shows that. This is why ending juvenile life without parole is necessary. These are kids. I can't stress enough the importance this legislation means. It's the difference between life behind bars and the opportunity for redemption, grace, and mercy that all of us at one point in time have benefited from. The state should provide the necessary help, resources, and training for these young people to re-enter into society. We must move from a more punitive, focused correction system to one that is centered around restorative justice. Just because a child committed a crime doesn't guarantee they will make the same mistake and commit another crime. A duly noted point, the recidivism rate for a juvenile that leaves the system is less than 1%. And many of my colleagues know that we've introduced these bills before, just last term. Many of my colleagues also know that I'm a strong proponent for criminal justice reform, as you are. So I come before you today, Madam Chair and colleagues, to finally move this legislation, hopefully across the finish line, to give it a real chance on the floor. I will add, without this legislation that we're speaking of today, it takes away the opportunities for these kids to have a second chance. The price, the place in society, the price they pay is with their life and their chance for change. And it's time, Madam Chair, that we take bigger steps as a state and be more effective in terms of our reforms as relates to criminal justice in the state of Michigan. Thank you for this time. I appreciate the opportunity.
Representative Vanderwall.
Good morning, Madam Chair and committee. Thank you for the opportunity to speak before you today. It's impossible to talk about these bills without talking about the word justice. House Bills 4160 through 64 changes sentencing guidelines so that juveniles cannot be sentenced to life without the possibility of parole. This is a concept I have agreed on with for several years and have worked on multiple terms. Obviously, most juveniles who commit a crime aren't facing a life sentence. So the portion of the young people currently could face a life sentence is limited to those who commit extremely serious offenses. It's important to have balanced justice when engaging in these hard conversations. The justice we seek is to bring with these bills is preventing someone whose brain isn't even fully developed from being punished for a mistake that they made as a kid for the rest of their lives. However, justice is also warranted for the families of the victims of these crimes, and while crafting any legislation, we must make sure that we bring them to justice as well. That's why I've been working on substitutes for these bills that I will make available for the committee members that hold both these concepts in balance. I will explain some of the highlights. The current version of the bills allows a juvenile who would currently be given a life sentence to get a maximum of 10 years before they become parole eligible. My substitutes would raise this to 25. As stated before, the human brain doesn't fully develop until 25 years of age. So as a 14-year-old who commits a mass murder would be parole eligible before the brain is fully developed. We must ensure that these children have the appropriate amount of time to learn, improve, and work towards becoming a productive and safe member of society. My substitute would also do away with the leniency for children who murder multiple people or shoot up, for example, a school, in the wake of Oxford School. Now it is appropriate time to be offering judicial leniency to the perpetrators of such senseless violence. The families of these victims must have justice. I'm happy to answer any questions on these bills or on the substitutes, but I really appreciate the opportunity to bring these bills forward and to work with you to make sure that we do what's right for everybody in this state.
Good morning, and thank you, Madam Chair. I just wanted to share something that just happened recently. So some of you know we've been dealing with the death in my family, and we were preparing some teenagers. And my 25-year-old took his two cousins, a 17 and 18, shopping. And he simply gave them two instructions. We need shirts with buttons, because all they want to wear T-shirts everywhere. We're getting ready for a service. And pants with zippers, because all they want to wear joggers, right? Every single time they were shopping, they showed up with a shirt without buttons and pants without zippers. And he said, "What are you guys doing?" And my son is 25. And he's just like, he couldn't believe it. Because simple concepts to kids are simple concepts. It was shirts with buttons and pants with zippers. And they couldn't even comprehend that. Can you imagine doing something, committing a heinous crime at these young ages and really grasping what it means, they're not thinking. And so when I look at this package of bills, I'm thinking about the grace, and I'm thinking about the mercy, and I'm thinking about what we call our prison system. We continue to call it corrections, but I'm wondering when we're ever gonna put forth some real work on helping people correct wrong actions, particularly these young people. I believe they should be given a chance. I don't believe this is us saying that nobody should, we're being soft on crime. I'll just say it. I don't think that's what we're doing. We're showing grace and we're showing mercy, and we're also looking at the fact that children's minds have not developed enough to really be able to comprehend what it is that they've done. So as my good colleagues have already said, I'm hoping that even with, as we continue to discuss substitutions and amendments and all of that, that the work that's been done will finally be able to get this across the line, and that our babies will be able to have the second chance that they need. Thank you, Madam Chair.
Thank you, Madam Chair, and thank you, committee, for having this hearing. I'll be brief. I think that there's a couple facts that have already been touched on in regards to the mind developing at a young age, and it hasn't really truly developed until age 25. That's one piece. The second piece is there's been plenty of studies that have shown that people age out of crime. And when we're talking about these teenagers, the recidivism rate, which Rep. O'Neill touched on, is so low, 1% or less, when we're talking about these teenagers. So I think when we're talking about grace and mercy, as Rep. Young stated, I think that's very important to keep in mind as this legislation moves through the House. Also, like Rep. Young stated, is that there was a crime that was committed. There still needs to be punishment. And we have a certain amount of years on here. And when you look at the maximum amount of years, we're literally talking about someone potentially getting out when they're a senior citizen. Clearly, someone who is not going to be a threat to society. So keeping in mind that we're talking about teenagers, juveniles, this is why I support this legislation. Thank you.
Thank you. We do have several questions, and I assume they're all for the bill sponsors. Representative Filler?
Yeah, so I'm reading this. The Oxford school shooter, Ethan Crumbley, is going to be sentenced in the next month. The Oakland County prosecutor is asking for life without parole. It may be granted because of the heinous nature. But if the bill package becomes law, Ethan could be let out of prison in 10 years if the parole board decided, and they take a look at the following things under House Bill 4160. Individual's age and immaturity. I mean, he's 15. Of course, he's going to be immature, right? Individual's family and home environment, and a lot of us are very clear that they had a bad home environment. So he seems like a pretty good candidate to be let out in 10 years. I find that unconscionable. I find that unconscionable for the victims, for the community that was terrorized. I just want to make sure I'm reading this correct, that your bill package would let out or allow the parole board to possibly let out Ethan Crumbley in 10 years.
If I can answer that for you, Representative Filler, I appreciate the comments, and yes, that's exactly the way the bill currently is written, and that is why we are currently working on a substitute that would address that situation. It wouldn't be fair to the victims, and it certainly, as a young man that committed that crime, we need to look at making sure that that is extended. So I look forward to making sure that you see those substitutes, and I believe you'll see that it's addressed.
Representative Arbit?
Thank you, Madam Chair, and thank you, sponsors. I do have a question about, actually first I wanted to just give a shout out to my constituent, Ronnie Waters, who has been a very vocal advocate and help on this legislation. I want to discuss like the difference between 10 and 25 and where that difference comes from and what sort of, stakeholders you've been working with to sort of get at like what is just and what is fair, because it's, kind of a nebulous concept, and understanding, what are, the sort of metrics by which we are, trying to, put in place to understand what is the right timeline for that.
Appreciate that, Representative Arbit. Again, it comes with working with stakeholders, working with lawyers, and really studying the human brain. And we understand that it doesn't fully develop until they're after 25. If somebody commits this crime, we need to look at each one, especially when you look at some of the heinous crimes, as were explained earlier, that we're looking at a mass murder. We need to address that, and we need to make sure, as I said earlier, that the victims are also brought to justice, but also the young people that create this, or the criminal, yes, that create this problem are looked at and properly punished, but also rehabilitated.
I guess my question is more of like, okay, so if someone commits a crime at 15, then the 10 years would be to 25, then, or if it was, 19 or 20, and then it's, then you get to 20, then they're in your 45 years old, right? And so I guess my question is there potentially another way than doing, sort of a one-size-fits-all sort of eligibility period after which, someone is eligible for parole, and sort of having either a series of standards or sort of like, if you're this age, when you like, I really think that that's my hesitation is a one-size-fits-all. And I think it may be more complicated, and it may be a lot more effort to sort of figure out what that looks like. But to me, it might actually be more effective and sort of better be able to balance the needs both of our public safety, the needs of justice for victims and victims' families, and also not making sure that individuals who do commit crimes at young ages are not sentenced for the rest of their lives. So I would just encourage you all to think a little more. And I appreciate the work that you have done so far, and I appreciate how hard you guys have worked, for consecutive sessions. But I would encourage you to maybe think outside the box a little bit and maybe move away from the one-size-fits-all to a more, nuanced approach in the eligibility period. Thank you.
Thank you.
Representative Mueller?
Thank you, Madam Chair. I guess this is to everybody in the bill package. As you can tell, as a former deputy, I'm probably going to be pretty opposed to this. But the one thing that we always tend to forget is the victims. And just recently in my area, a case that I'm very close to, there was a woman named Corinne Baker. Her and her boyfriend brutally murdered a young man over 3 days in the apartment, and he was sentenced to life without parole. She was sentenced to 13 to 30 years. She was paroled just recently at her first date, and communicating with the father, they were never notified. MDOC did not notify the family until it was too late so they could oppose the hearing. And now this woman who stood by while her son, Dominic Calhoun, and now we have Dominic's law, was brutally murdered. And the amount of the emotion that it had on our community, you really have to look at victims' input into this. So when the parole board has something, these people cannot be let out of prison until the victims have a say in it. And that they have to be the instrumental part of this whole package, if it's going to go anywhere, is the victims, because they're the ones that don't have their son, they don't have their daughter, they don't have their father. And a lot of times these crimes, as you know, are senseless. All three of us have been to homicides. And when you go into a homicide where there's a 6-month-old baby dead, that sticks with you for the rest of your life. A 13-year-old boy in West Willow, 14-year-old boy in West Willow, murdered, shot numerous times as they left the house because he got upset because they shot the dog as someone was hiding in the closet. My partner and I were the first ones to that. So you have to look at some of the way the crimes are, but a lot of them are senseless. And they take away someone's life over a pair of tennis shoes, and now you have 2 people that are gone. But I'll stop rambling, but the thing is you have to have victim input in this. And if the victims don't go along with it, because people can be forgiving. My last day at work, a guy tried killing me and he got sentenced to 12 to 25 years, right? I don't think that's an appropriate sentence for this person. It should have been 6 to 12, but he refused a plea deal. And now he's serving 12 to 25 years. And I have half a sentence to ask the governor to commute a sentence to what it would have been, because that's fair. But I was the victim. I had the input. When you start messing with people's lives like that, you really need to consider the victims. And then I'll get off my soapbox. Sorry.
You're not on a soapbox. Thank you. No, because we do. The only reason we're having this discussion because there's somebody who committed a crime and there's a victim. And the one thing I don't believe there's anybody here, any of these bill sponsors who aren't thinking about victims. But we are thinking about what caused the child to create to do the crime to begin with. Let's just be honest. My kids would not probably be the ones who we would find having committed one of those crimes that you discussed. But at the same time, they tell me about when they were growing up, about the horrific homes that some of their classmates lived in. I would tell them, they would say, I don't understand why the kid's so bad. They got in trouble for saying this and saying that, and one young man came home talking about he just watched the movie Scarface. This was in 2nd grade. So there are reasons why these kids end up violent. There are reasons. And so some of those things need to be taken into consideration. That's all. I think that's what I'm saying. Let's take into consideration some of the backstory when we're looking at this. And then you're right. There's no reason that families shouldn't be notified when it's time for parole. I'm pretty sure parole boards are I'm hoping they'll do their due diligence. Things clearly seem to happen, but they've got a job to do just like we do. If they do their job right, if there are areas where we're saying, yeah, this one's just not right, it's just not time, then they won't be let go. Am I looking at this wrong, colleagues? Amen. Who's next?
Representative Devendorf.
Thank you, everybody, for introducing this important package. I speak today as somebody who has worked on homicides in my role running a victim services organization. I've worked on homicides that are hate crimes, which can be some of the most gruesome crimes. And still, I caution us to not continue the pattern of creating policy based on our own frustrations, fears, and anger, and to create models for the rest of the country that show that we have learned what works, what is effective, what will create healing, what will create reform, what will ensure that corrections is actually a place where folks have an opportunity to correct, to live a better life at some point. With that in mind, I have hesitations about what Representative Arbit brought up in terms of the one-size-fits-all response. I believe that it is counterintuitive to our knowledge of the neurological development and the fact that it is still in process. While acknowledging that so many of these things that we would create a carve-out for are scary things that create a big impact. They can also be huge mistakes. They can also be unwise decisions. They can also happen because you are a part of a group. They can be things that occur because of immaturity and because you are not the person that you can be. And I need us, as we have so much power in this space, to be, as Representative Young said, considering context, considering the development that can be, and not thinking of some crimes because they are scary and dangerous and hurtful as places where reform can't happen because we are scared and hurt. I hope that we do allow for judicial discretion. I hope we do allow for not a one-size-fits-all response to this, and that youth can be revisited after 10 years regardless, because we know that prison can continue to shape a brain, and not in the way that would be conducive to a safer society, or a society that will help that individual once they get out. At a certain point, the opportunity and ability to heal hits a wall. For these youth, let's try not to get to that wall. I hope that we reconsider that aspect of this legislation.
Representative Bagol.
Thank you, Madam Chair, and thank you to my fellow representatives. As I'm sure you know, in 2012, the United States Supreme Court decided Miller versus Alabama. The Miller court held that juveniles, those that are under 18 years old, have a diminished culpability and greater prospects for reform when compared to adults. In 2016, the Supreme Court went even further under Montgomery versus Louisiana. They held that juveniles sentenced, that the court case applied retroactively to those offenders as well. Since 2012, no offender under the age 18 has received a mandatory life without parole sentence, regardless of the circumstance of the murder committed. And my question is, why would we raise the age from what the Supreme Court says now and include the adults? And do you anticipate later on going even further? I know there's been some ages mentioned up to 25 years old that the brain is not developed.
Representative Carter.
Sorry, Madam Chair. Representative, can you kind of refine that?
Sure.
Please.
I'd be happy to do that. So I'm wondering, why would we increase the age from what the Supreme Court has said, 18 or below? Why would we raise that age to 18, 19-year-olds? That's my first question. And my second question was, do you anticipate that this effort will be extended to even older later on? Because I know there's been some talk about the brain of all the way up to a 25-year-old not being fully developed.
You got the 25-year-old, but I will add, if I will, you know, there's a lot of data and research that shows the development, and males develop slower than females. That's documented, but the brain develops at a exponentially rate higher when they reach that 20, 21, 22, 23. Things change. You're not the same person you were at 14 than you are today, right? Just thinking, just right now. And so there may be some discussions, and thinking about the victims, we've all considered the victims in this situation. I was at a meeting yesterday, meeting with my superintendents, meet once a month. After that meeting, the waitress came up to me. I didn't know her, she didn't know me, but she knew, obviously she knew me because she asked me a question about this bill. We had a terrible case in Saginaw. Karen King was brutally murdered, and she was a family member of Karen King. I listened to the young lady, and she was in tears, and I was calm and patient with her, and I expressed the intent of this bill. And the crime that this young man committed was heinous. Now, I, as a state rep and a compassionate person, if I was a parole board person, I probably would deny this person's parole. And that's the decision of the parole board. And I trust the parole board's ability to make those sound decisions. That's why we put them there. Okay, and so those are cases that will be decided not because of this bill, but it gives that person a chance to be considered. And that's, I think, and that's what I explained to her. She thought it was just a slam dunk. After 10 years, this person's going to get out. And I said, no, ma'am, that's not the case. She said, oh, well, thank you, Rep. O'Neill, thank you. And I just wanted to just express to her that a lot of clarity is being shared with a lot of people on this matter, okay, to your point. And so there may be some discussion on ages, but the point being is, at that 10-year mark, that just simply says, this package of bills just simply says, these individuals will have a potential for have a parole board hearing. Just like this is a distinguished board of wise people, that parole board is the same. They will make that decision. And when you think about Michigan in totality, to my colleagues, the whole system is screwed up in terms of, crime. We support crime. We support, law enforcement to reduce crime. But you look at the whole system. When we make decisions on the House floor, whether to make sure 3-year-olds can go to school and have early childhood education, or that parent that's working 2 jobs can have support child care to make ends meet. Those are in totality some of the cosmics that we deal with as a state and representatives when we make decisions. So it's not just we dealing with this issue right here. The whole system that we have to deal with when we make decisions impact this. So if we start early and say, let's support those 3-year-olds going to child care. Let's support early childhood education. Let's support programs that support families when they're trying to make ends meet and working 2 jobs and living in poverty. This is a result of the system. And so we're trying to say, hey, representatives, let's look at how can we be more merciful and give a person a chance to correct their wrongs. We all made mistakes. All of us have. We all had second chances. There's no one in this room and no one listening to my voice has not had a second chance in life. No one. And that's all we're saying. We spend more money in Michigan than any other state for corrections. I'm the chair of corrections. I know. More money than any other state, than Mississippi, Louisiana, those southern states. Michigan, I'm not proud of that. I'm proud of a lot of things we've done in Michigan, but I'm not proud of that. I'm not proud of the fact that we let our inmates spend more time locked up than any other state. I'm not proud of that. I'm not proud of the fact that we don't have any incentives for our inmates while they're in prison to say, corrections, reform. I would rather have a person get some information in prison or change their behavior in prison by having an incentive say, well, if I maintain myself, I got good time or credits that I can work toward to reduce my sentence. This person's mind is going through a process, okay? So this is a big picture, guys. I'm looking at the whole picture. If we want to go that way, we don't have time, but the system created this, unfortunately. And I am sympathetic to the victims, like the lady that stopped me at the restaurant yesterday.
Representative, I hate to interrupt, but we do have several more representative questions and then several folks who would like to testify. We have about 18 minutes left, and it's mathematically impossible for everyone to testify. But I'll take one more question from Representative Carter.
Thank you, Madam Chair. Representative O'Neill, just for the record, I'm on my 5th second chance. So, as a person who has that background, I actually ran the juvenile detention facility and the youth home, and Lincoln, for those in Wayne County, know that as the juvenile court. And I got to know some of these young people, and what we're talking about is root causes. We're talking about getting to the bottom of, most of these kids were not bad kids. I've run into a couple that, thank God, they were locked up. But for the most part, they were products of their environment or lack thereof. And so we have to look at this, like you say, big picture holistically. Because I go way back. People in here probably aren't old enough to remember Young Boys Incorporated in the city of Detroit. Okay, and then you're telling your age. But also in 1999, the state of Michigan charged an 11-year-old as an adult, Nathaniel Abrams, sent him to prison. He was 13 when he got locked up. The system failed him when he was inside. He came out and he went right back. So we have to look at this. And there are victims. And there are some people that want people to rot in hell after they've harmed their loved ones. So we've got to find the balance and try to figure out what kind of society we want to be. So I'm not going to ask a question for the sake of time, but we can have these conversations. Thank you.
Madam Chair, I apologize for ranting. My apologies.
No, no apology necessary. Representatives, if you wouldn't mind holding your questions until perhaps next time, or if you feel like it's really urgent for these bill sponsors right now, we can take it. No? Thank you. So next we'll have Ronnie Waters from Safe and Just Michigan, and Leon Douglas, if you don't mind coming up as well.
Good morning, Madam Chair and committee. My name is Ronnie Waters. I'm what some people call a juvenile lifer. I was sent to prison at the age of 17 for a crime that I definitely committed. I went to prison knowing that I would be punished and punished severely for my actions. That was just afterthought. But when I got to prison, I just wanted to try to figure out how to become a better person. Instantly, I wanted to figure out how to become a better person. So many negative things were said about me, and to my detriment, most of them were true. But I knew that wasn't who I was, and I went there to try to rehabilitate myself. Even though I was barred from most of the rehabilitative programs, I still was able to get into a lot of things, programs that I was not eligible for, because I wanted to be ready in case I ever got a second chance, in case I was ever able to prove that I was less culpable than what I was charged with. So everything positive, everything rehabilitated, I did it. I didn't have an out day. I didn't have what some people would call a future, but I knew that I had to do things just to make myself better. And in 2012, as someone said, Supreme Court changed that for me and said I could have a second chance. It took me 10 years after that 2012 ruling to actually get that second chance. And after 40 plus years of imprisonment, I was able to prove that I was rehabilitated, that I was redeemable, that I had value. And I came home, and everything I do out here is to prove that I'm redeemable. And I know that people are watching me. And I know that I have to be the example for the good people that I left behind. Left a lot of good people behind. And I'm out here advocating for them to also get their second chance, because I know these people personally, and I know how important it is for a person who is branded a juvenile lifer to come out and do the right thing. When so many people were saying that you're trash, you're worthless, you're scum, and I rejected all that. I knew that I wasn't. I knew that I could contribute, and thank God that I got a second chance. And thank God that a lot of good people are waiting on that second chance, and maybe they can get it also. Thank you.
My name is Leon Douglas.
Sir, please turn on your microphone.
Thank you. My name is Leon Douglas. I'm a lifer. I was a lifer without parole. I was given the opportunity and chance of my freedom August of last year. I've been out since then. I've had 4 jobs. I'm working as we speak. I've done everything that was available to me in prison that I could do in order to better myself. But for me to sit here and tell you that it's like I was a model prisoner, I would be lying to you. I killed a person doing a robbery, and I don't feel good about that. But at the time that I did that crime, I was a blundering idiot. And I admit that, and I didn't have no care or worry about anybody, because that's just the way I was, that's the way I felt. During those years in prison, I felt there was no way possible that I could be able to rehabilitate myself and make a change in my life. Well, I'm not going to sit up here and tell you that God came in my life and gave me hope. I'm not going to tell you that. But people gave me hope. People like yourselves. It was a judge that got involved with me by the name of Fred Mester. Some of you people may know him. He got involved with me, and he wanted to help me because he seen the type of individual I was. I did 50 years, and nobody even came to my help. No one, other than Safe and Justice, my friend here, Ronnie, and they came to help me along with Judge Fred Mester, who gave my release. I was given a re-sentence, and I was given 40 to 60 years. I know some of the state representatives feel and believe that some of us are psychopaths and we don't deserve a chance at freedom. I look at you today and I say to you today that I deserved a chance. I was sentenced to a death sentence. Year before last, I was given a 5-year sentence along and attached to my sentence that I was already doing the time for. They gave me an extra 5 years, saying that it's like they'll see me in 5 years, which the parole board never seen me except for 3 times in all the 50 years I was locked up. They wanted me, and they gave me an extra 5 years. In other words, I would have been doing 55 years before I would even been considered being released. I just wanted to know and let y'all know that it's like I'm here to support juvenile lifers without parole, and please know and understand it's like I appreciate all the state reps that is fighting for these bills. Thank you.
Thank you. We're going to move on to Crystal Grigonis and Michael Sepik. And Karen Jackson, please. Michael's on Zoom. There he is. Whenever you're ready.
Oh, I'm sorry. Thank you very much for the opportunity. I am Michael Sepik. I retired as the Berrien County prosecutor at the end of my term in 2020. I was the elected for 7 years. So I was the prosecutor during the.
Sir, your sound isn't working.
Sorry?
Can you be louder, please?
Oh, sure, I'm sorry. I was the Berrien County prosecutor when Miller came down and when Montgomery came down. Is that better, volume-wise?
It's a little better. There might be a problem with your connection, though. It's very faint.
Okay, so Berrien County had 12 juvenile lifers in prison. When Miller and Montgomery came down, we filed motions in all those cases. Of those 12, we agreed to a term of years in 7. We went to Miller hearings in 5. 3 of those Miller hearings resulted in a term of years. Two different judges sentenced 2 individuals to life without parole. That was before the Michigan Supreme Court's decisions last summer in Parks and Taylor. So both of those juvenile life without parole sentences have to come back for re-sentencing. I don't know what will happen to them. But the reason I am speaking against these is that it seems to me the legal lay of the land right now allows for Mr. Waters and Mr. Douglas, as we have seen, to have judicial discretion here to decide that if their childhood trauma, their dysfunction in their household growing up contributed to their crime, then judges will give them term of year sentences. I tried a case in 1989, which is one of the 2 that the judge sentenced to life without parole, a 15-year-old who decided he wanted to kill. It was not a robbery, it was not a fight, it was not an argument, he was not on drugs or alcohol. He wanted to kill. Chose his grocery store manager to kill. He was a bagger. Here's a kid who was 15, and contrary to Representative Fuller's statement that if you're 15, you're immature, This 15-year-old had an after-school job, good grades in school, two-parent household, Key Club member, junior achievement member. He was a star student, one any of us would be proud of, but his brain somehow wanted him to kill, and he did. And
Mr.
so I
Sepik.
think your
Mr.
legislation,
Sepik. I'm very sorry to interrupt, but we do have two ladies here who would like to share their stories before we conclude. We will be kicked out of this room in about 5 minutes or less. So I hate to interrupt, but share one more thing really quickly.
let me just say that I think the current lay of the legal landscape permits what you really want to do here. And I think what you really want to do is permit a judge to make that decision. Why don't we trust our judges? Thank you.
Ladies.
Thank you, Madam Chair and committee members, for making time for my testimony here today in opposition to House Bills 4160 through 64 concerning juvenile life without parole, which I'll refer to as JLWOP. My name is Karen Jackson. I'm a co-victim of murder. My son, Jeffrey Belor, and his female friend, Kristen Pangman, were brutally stabbed to death in a double homicide in 2017. I speak here for myself, my family, and for other co-victims who belong to a group I manage called Voices of Murder Victims. There is little time here to properly convey the depth, severity, and longevity of the trauma we co-victims experience, so I am also providing the clerk with an essay on my personal story to share with all of you. Even with limited time, I would like to recognize our innocent loved ones who were killed brutally and savagely. These victims no longer have a voice or a say in your proposals and decision-making. That is left up to us, the co-victims. As co-victims, under the most agonizing of times, we are forced to seek justice for the deaths of our loved ones while picking up the pieces of our own lives and holding together what remains of our broken families. The trauma caused by losing a loved one in such a brutal manner leaves us with a host of issues. One of the most pronounced, and the one that I wish to point out today, is the lifelong impact on our mental health. I know of no co-victim that isn't affected in some way with mental disorders like PTSD, anxiety, depression, and fear. A killer doesn't just take lives. They destroy the ability of whole families to function in healthy, productive ways. The Supreme Court decisions concerning JLWOP have come as a huge blow to what we co-victims recognize as justice. Our assurance that we would never have to fear for our safety, that of our families, and the public has been taken away. Further adding to our trauma is the introduction of these bills. We feel that they lean to the side of leniency for the guilty juvenile murderer while disregarding the impact on innocent co-victims. We oppose legislation that repeals MCL 76925 and 25A and sets incarceration at a set term of 10 to 60 years. A killer having already served more than 10 years of a sentence would be eligible for parole review and subsequent immediate release if approved. We reject any notion that a parole board could deem a killer to be rehabilitated to live in society as justification for reducing sentencing. We do not believe a parole board assessment of the behavior of the killer over a period of years in a closed, regulated environment will guarantee that those behavioral changes will hold true outside of prison. We oppose legislation that removes all possibilities of JLWOP and removes all options to evaluate each case based on its own merits. Although we must respect the Supreme Court's decision, we do not support any legislation that goes beyond what is necessary to satisfy the Supreme Court's ruling. We ask the committee to acknowledge the continued life struggles and especially the mental health issues of co-victims as paramount to raising our own children and families and living productive and socially accountable lives. We ask the committee to recognize the concerns of innocent co-victims above that of the guilty juvenile murderer. We ask the committee to oppose these bills. Thank you.
My name is Crystal Gregonis. On or around September 16th of 2000, my ex-boyfriend threatened to kill me. I moved to a shelter for domestic violence. On October 1st of 2000, he broke into my son's bedroom window. He stabbed my sister several times. He stabbed my brother several times, murdering him. And he stabbed me 15 to 20 times. nearly killing me. My brother's murderer will not serve 1 day in prison for stabbing me, almost killing me, or my sister, the way the laws are written right now. My brother, we all deserve justice. I'm sorry, I'm foggy. My head was beat several times that morning. I'm going through physical problems to this day. It's been 22 and a half years, and I'm still going through physical problems. I have mental health problems. I'm on several medications, and I see therapists, psychiatrists, because I'm scared he's in prison, but I'm still scared he's gonna kill me. It took 7 years for me to be able to even sleep alone in my house. 10 years is a pure slap in the face to anybody that's ever been in my position, because at 7 years, I still felt like he was gonna kill me. He was in prison. I can't say enough how scary this is. For the past 2 months, my life has been hell. I got a phone call. We resentenced on May 5th. My ex was sentenced from life without parole. He was 18 years old. He was 4 days shy of 19. He is now serving 35 to 60 years, which means he'll be out in 12 and a half years. That started my 7 years again. I can't live my life. The day he leaves prison is the day that I stop, because I'll be watching my back every day, because he came to kill me that morning. I don't know why we're here. I don't know why we're even discussing people that have already hurt somebody so bad. There are so many other things we could be talking about today, and I don't understand, and I'll never understand this, but I ask that you please, when you vote on this, that you think about my life, my brother's life, and my sister. We deserve justice, and he was given that opportunity, and he already made his decision. Thank you.
I'm sorry for your loss, and I appreciate your willingness to testify.
Thank you.
There are several cards that will be recorded in the minutes. There are no absent members. And we will take up this issue again. There being no further business before the committee will stand adjourned.